Hi, everyone. Welcome to our webinar on key EAR and OFAC developments from 2020. Also, welcome to our participants from outside the U.S. I know it's difficult with the different time zones, so really appreciate that. Before we get started, just a few housekeeping items. The call will be recorded, and we're also offering CLO credit for attorneys who want that. We will give out the code during the presentation, which you can write down, and then after the presentation, you will receive an email with the CLE form that you can complete and submit then. If you have any technical difficulties, please use the Q&A function. We have someone manning that, so folks can help you with that. If you have any questions during the presentation as well, please use the Q&A, the chat function, to put your questions in there. We will collect all questions, but just given the brevity, we have 60 minutes. We will not go through questions during the webinar. I've noticed that oftentimes they're just very, very fact specific, and I think you'll get more out of it if you talk with us directly. So David and I will be available. We take on every question that you submit, and our contact information is here too as well if you have any questions that you just want to submit over email or call. With that, I would like to turn it over to my colleague, David, who will start it off with change to classifications.
Alexandra, Thank you, Alexandra. Welcome to the 2020 year in review. As many of you know, Alexandra and I provide a complementary set of skills to our export control practice. While Alexandra has extensive experience with the regulations, I have extensive technical experience, having worked as a software and systems engineer and a manufacturing engineer, as well as experience working for the Department of Commerce in the U.S. Patent and Trademark Office. So I'm going to cover in this first part of the presentation the major changes to classification, the changes that affected the Commerce Control List that were implemented in 2020, and we'll walk through those, one at a time at a high level. Next slide, please. Okay, but I've provided this slide, which identifies all of the major changes that we're going to address in the presentation, as well as references to the Federal Register notices and the dates in which they were implemented. You will find links on the BIS website to each one of these if you want to review them in detail. And as Alexandra mentioned, if you have any questions, you should feel free to contact us. Our contact information is provided in this presentation, which is available or will be made available later on. Next slide, please. All right, so the first change of 2020 came as an obscure addition to Category 0. Specifically, it relates to the 0Y521 series ECCNs. For those of you that are not familiar, the 0Y521 series ECCNs were instituted back in 2012 to provide a mechanism for BIS to propose controls on emerging technologies. It's moved around a little bit. I provide the section reference. It's in the EAR section 421, identifies how this was implemented. The regulation itself creates a group of temporary ECCNs in Category 0 designated as 0Y521. And interestingly, they expire after a year. If they're if they're not moved to a permanent ECCN or extended, they result in an EAR 99 classification. So let's look at the substance of what this control does, because it's a first attempt by BIS to control machine learning and artificial intelligence. The software, the control relates to software that's designed to automate the analysis of geospatial imagery using artificial intelligence and machine learning. And again, this is, it was a, obscure addition, but it's an interesting to see that while BIS on one hand is promoting rulemaking for, as we're all waiting for the export control reform regulations to come out, how they're going to classify and identify emerging and foundation technologies. This is an attempt to simply propose a control and see how it works over a year. And now, as you also may know, they extended it for another year most recently. So these are the kinds of things that we should expect to see over the next year or so. Next slide. Okay, so unlike the first item, which was rather obscure, most of you are probably aware that there was a major transition involving the movement of firearms, guns, and ammunition from the USML to the Commerce Control List. This was, extensive regulations that were implemented in the beginning of 2020. It involved major changes of both the USML and the Commerce Control List. And it's even the subject of litigation that's going forward. Both DDTC and BIS went out of their way to emphasize that this was not a decontrol or a deregulation of firearms, but rather a reorganization for purposes of efficiency. It was intended to reduce the regulatory burden on the U.S. firearms industry, which produces, dual-use items, as well as to better align the burdens on DDC and BIS. DDD could then focus solely on military arms manufacturers, while BIS could focus on dual-use items. Next slide, please. Sure. So for the ITAR, the final rule makes significant changes to categories 1, 2, and 3 to more clearly distinguish defense articles that are inherently military and not otherwise widely available for commercial sale. The amendments are intended to provide clear lines between the USML controlled defense articles and CCL controlled dual-use items. As I mentioned, there was a lawsuit that was filed by the states. It's pending in the Western District of Washington, and it concerned primarily the controls that were related to software and technology that could be used to produce firearms, the primary example being 3D printed guns. The case is ongoing, but the court issued an order that essentially required the DDTC to continue to issue licenses until the litigation is resolved. So if this is an area where you work, presumably you're aware of this, and if you're not, we're happy to help you. But in essence, you're going to continue to go to DDTC for certain licensing issues. Next slide, please. Okay. So on the Commerce Control List side, as most everybody's aware, there are the so-called 600 series ECCNs, which were created a while back as a way to classify USML items that have been moved to the CCL. Yes, moved to the CCL. So the regulations create additional 600 series ECCNs to control the larger caliber guns and military weapons that were transferred from the USML Category 2. So if you were previously in USML Category 2, your export classifications now can be found in the new 600 in a set of new 600 series ECCNs. In addition, BIS created a new 500 series ECCNs, and those are going to be used to control the dual-use firearms, weapons, and ammunition that were transferred from the USML categories 1 and 3. In total, 17 new ECCNs were created, 8 were revised, and 9 were actually removed. It's important to note that EAR Section 734.7 that relates to publication was amended to clarify that the software and technology for the production of firearms that are controlled in Category 0, 0A, 501 would remain subject to the EAR, even if they were published on the internet. So like encryption source code, that's open source and published on the internet, this is another exception that now exists that you should be aware of. So even if it's published on the internet, it's still going to be subject to control under the EAR. Next slide. Okay. So the next set of changes that took place, changes to the EAR, we were all in lockdown, and it seems like BIS used this as an opportunity to catch up with its, harmonization efforts to update the CCL to meet the Australia Group and Wassenaar arrangement requirements. So the first change that took place in February, that took place later in 2020, was to amend the EAR to implement the Australia Group intersessional decisions from February. And those are primarily directed to those in the life sciences field. Those of you that are working with controlled chemicals and viruses, toxins, and pathogens, you should be aware that 24 new precursor chemicals, as well as the MERS-related coronavirus, were added to the CCL. So if you're managing these kinds of materials, you should just be aware of them, that you may have to update some of your controls and compliance. In addition, it also adds single-use cultivation chambers to the CCL. Probably a few people here that might be relevant to. Next slide, please. All right, so the first Wassenaar implementation amendments took place also in 2020. This one is harmonizing the CCL with the 2018 Wassenaar arrangement changes. As you can see on the slide, the rule amended ECCNs in categories 1, 2, 3, 5, 6, 7, 8, and 9. So there have been many changes and revisions based upon this. Some of them are going to be small, others more significant. As we've said before, periodically you need to review your classifications and just make sure that you're staying up to date. This year, like many, the CCL changes, and it makes sense to review your classifications to see how these changes might impact you. Next slide, please. Okay, so the next set of changes related to the implementation of Wassenaar 2019 these are multilateral controls, and these are directed to recently developed and developing technologies. These are, the emerging technologies that BIS is working on. This is sort of a parallel process in that, these came out of the Wassenaar arrangement. So in this case, it makes changes to 10 ECCNs, primarily in categories 2, 3, 5, and 9. Next slide, please. And as you can see, these are cutting-edge technologies. We're talking about hybrid additive manufacturing and CNC controls. That includes 3D printing. The additional controls related to computational lithography software. That's that's cutting-edge technology with respect to the manufacture of semiconductors. It also covers technology for finishing wafers for the 5 nanometer production node. Again, more solid state semiconductor technology. It also implements changes to controls on forensics tools for circumventing authentication and authorization controls, and software for monitoring communications, as well as suborbital aircraft. So any of these new areas, if you're working in these fields, you should take a look at the new controls. Next slide, please. Okay, so here we're going to go through some of the proposed rule changes. There were 3 that were implemented, that were published, in 2020, and this relates to the events that took place in Hong Kong in the last year. The first one discusses advanced surveillance systems and items of concern in human rights. So again, this is directed, to some extent on what's been happening in China versus, both in Eastern China and in Hong Kong. It relates to crime control and detection items, including facial recognition, disruption lasers, long-range acoustic devices, police helmets, fingerprint readers, and voice print ID systems. So these are, again, technologies that have existed that now we're gonna control for specific areas for human rights purposes. The second proposed rule, again, we're going back to foundational technologies. In this case, BIS is seeking public comment on a definition of foundational technology and criteria for identifying foundation technology, something that we're going to start to see more of in the next few years. Let's see, the third proposed rule relates to software for automated nucleic acid assemblers and synthesizers. This relates to technology that allows for the production of the synthesis of pathogens and toxins without having the need to acquire certain genetic elements that would normally be used. So these are items that could potentially be hazardous and dangerous in the wrong hands. One final comment is that, as many of you know, BIS has also issued regulations relating to the ICTS regulations, I guess they're being called. It's the Information and Communications Technology and Services regulations. They're not really, what we would call export control, but they're along the same lines in the sense that they're going to, along the line, actually these are somewhat like a CFIUS kind of regulation, where if you're involved in, for example, you collect sensitive personal information relating to more than 1 million individuals in the United States, and your computing technology or services utilize equipment that was manufactured in a country that's controlled by a foreign adversary. We're thinking China, Iran, South Korea, but primarily China is a major focus here. That BIS, not BIS, but the Department of Commerce will be looking at those transactions to see whether it creates a threat to national security. So, that's something beyond the scope of this discussion, but we felt it was worth mentioning because it's something that's very new, and it's going to relate to many people that are doing this kind of work. Next slide. Okay, now I'll hand it off to Alexandra, and she'll talk about the changes to policies, rules, and license exceptions. Thank you.
Thank you, David. So yeah, it's been a busy year on the ITAR and in particular the EAR CCL side. So as David said, now we're going to switch away from classifications and going over to regulatory changes. The way I organize that is by destination. We talk about Hong Kong, China, Russia, Venezuela, and some others. So first, the focus on the EAR, and then we take a look at key changes on the OFAC side and also some interesting OFAC enforcement actions. Okay, so let's kick it off with Hong Kong. So in July already, given the events in Hong Kong, there's already some activity here on the EAR side. So BIS announced that all license exceptions that one could use for Hong Kong would no longer be available if one couldn't use them for China. So essentially as simple as that. And then over the course of the year, and I walk through this, basically what's happening is, as we all know, Hong Kong is really part of China, right, politically, one country, two systems. But in the EAR, Hong Kong has been treated as a separate country, right? It had its own entry on the Commerce Country Chart and license exceptions. Actually had over the years a pretty beneficial, pretty good standing. And that was slightly degraded in the last couple of years. And now, really, we're seeing it being completely pushed down, if you like, to the level of China. And that's not meant to be derogatory, but just as we all know, we take a look at the ER and the restrictions that apply to China. Those are strict restrictions. So Hong Kong is now subject to the same restrictions. So again, that kicked off in July. In October, then, given demonstrations in Hong Kong, there were controls on water cannon systems that could be used for riot control. In December, then, we were all waiting for this. In December, Hong Kong was removed as a separate destination. This is really important. Now, many of you export to Hong Kong, through Hong Kong. And so essentially, Hong Kong as a separate destination of the EAR no longer exists. There are some exceptions because of customs regulations in the EAR, but essentially Hong Kong no longer has its separate status. So it falls under the same restrictions as China. So what does that mean? For example, Hong Kong is no longer listed in country group A6. A6 was good. One could use license exception SDA for highly controlled items for Hong Kong when that applied. It also is no longer in country group B. Country group B, right, was nice license exception there. GBS, TSR, no longer available. Instead, Hong Kong is now in country groups D, so that's bad, right? For example, D5 are the ITAR embargoed destinations. So it's exactly the same restrictions as for China. These restrictions apply. That also has implications for other license exceptions. It has implications under country group D1 for encryption. So again, important changes here. Next slide. On the EI side, as many of you know, given changes that were implemented, and I'll talk about them in a moment, regarding China, Russia, and Venezuela for exports that could go to someone that is defined as a military end user or a military end use under 74421. There, BIS implemented a change that regardless of value, you have to file an EEI if your item is on the Commerce Control List. So you could have an item that is theoretical, right? But it could be worth $1. It's on the Commerce Control List. Could be a pretty innocuous item, pretty simple laser sensor. You'd have to file an EEI. And why? Because BIS wants to know where it's going and if there is a control that applies. Now, the same requirement applies to Hong Kong. And it's a little tricky because the AES requirements still say that the EI has to be filed for Hong Kong as a separate destination, if you like. But keep that in mind that the same requirements as for China apply to Hong Kong. So we no longer have that $2,500 threshold where for all other destinations, if you have a shipment that is below $2,500 and something is on Commerce Control List, you don't have to file an EEI. Here you have to file an EEI if the item is in a Commerce Control List, regardless of value. Now, as I said earlier, some ER provisions still retain references to Hong Kong just because Hong Kong still operates a separate customs system and a separate export control system. But essentially, the controls as we think of them is a license required. Does a license exception apply? All of those are the same as for China. Essentially, Hong Kong is China now, part of China. Also under, it's been like that, right? Politically, but also under the EAR. The special restrictions for microprocessors, so if you produce, export, re-export them, you should take a look at that under 744.17. Then very important here, point 7, for those of you who have had to deal with these new military end user provisions under the EAR, because your items fall under supplement number 2, for example, spectrometers 3A999, mass market encryption 5A992, 5D992, aircraft parts 9A991, and several others. Now, even though 744.21 talks about China, Russia, Venezuela, and we've all, right, for many years have not viewed Hong Kong as being part of that. We read China in the EAR. I think most of us have just excluded Hong Kong. You just have to remember these restrictions now also apply to Hong Kong. As I said earlier, Hong Kong is now also in country group D1. That's a problem. When the foreign produced direct product rule applies, what does that mean? I'm going to simplify that. That means I'm abroad, I'm producing an item, I'm producing, say, a laser, and my technology, right, my know-how, the secret sauce, comes from the U.S. I don't have any content in my item. Let's say my laser has 0 physical U.S. content, but the know-how came from the U.S., for example, because of an acquisition or a licensing arrangement or whatnot. Now, if what came from the U.S. would fall under a national security control, and what I'm producing, say, in the UK, in France, in Germany, in Japan, would also fall under national security concern, my laser, so 2 times NS, and my destination is a D1 country, which is now also Hong Kong, then I have a problem. Even though my laser, in this example, has 0 U.S. physical content, right? No part, no component, no material, nothing, no software from the U.S. The secret sauce came from the U.S. It's not subject to the EAR, and the same controls apply as if I just exported this out of New York or California. So that's important because we didn't have that for Hong Kong. That's equally important, of course, for Huawei, right? We have an even stricter restriction under the direct product rule. I mentioned this earlier for folks that produce items, hardware, software that has encryption functionality. For example, a mass market item may fall under 5A992, 5D992 there. This has been the issue for years. The technology is actually higher controlled. The development production technology falls under 5E002. Now, if you use contractors in Hong Kong or others you would like to provide the technology, right, your secret sauce to say, that would no longer work. You need to get a license for that. License exception 740.17 B24B would not apply. And that's just important to recognize because, again, we didn't have that for Hong Kong. And then throughout 2020, and we'll see this coming, many individuals in particular, also politicians, including Carrie Lam, were added to different lists. So entities were added to the entity list, and individuals were added, for example, to the SDN list that OFAC administers. So a lot there, and we're expecting more movement here as well. Next slide. Okay, so moving on to China, of course, many changes there. It's clear, right? There's tension between the U.S. and China. And from the U.S. side, concern about what the U.S. views as a civilian military fusion, right, where there's a bit of a gray, where it's not clear. Is it really, something going to be used for civilian end use, or no, it could be, it could help the People's Liberation Army or defense industry in China. So there was a provision, 744.21, that's been on the books for many, many years. It came out over 10 years ago. Many folks are not aware of it. That was okay. It wasn't really too important because it didn't catch many items. Now it's important because it catches much more. So it came out in April and was then implemented in June, and it's been a real headache. And I know many of you here on the phone are dealing with it too and know it. And what it means is this: if I have an item, I mentioned some earlier, say an aircraft part that falls because of its classification, say 9A991, under Supplement 2 to Part 744, it has a low control, right? If I go into the Commerce Control List, in the Commerce Country Chart, it would say, oh, it's an AT control. Normally it would say, oh, AT, that's great, right? Anti-terrorism, that means it's just an issue for countries that sponsor terrorism. Country Group E, that's an issue for Cuba, Iran, North Korea, Syria, but not for China, right? But now it's an issue for China, Russia, Venezuela. So it's a bit of a catch-all control. And what BIS changed too was the definition. So the definition used to be pretty narrow. It used to be the military, of course, right? No surprise there, the Army, Navy, and also intelligence agencies, the national police. That sometimes was surprising to some folks. Understandably, not necessarily the military, but now it also includes a private sector entity or a university or institute, whoever, in China who supports military end users in China. I've given this example before, but I'm going to give it again because I think it's a good one, just to understand what that means. Say I have an end user in China, a customer, okay, and I'm going to sell a measuring device that can be used to test infrared thermometers. And my customer in China produces infrared thermometers to fight COVID-19. That's a fabulous end use, right? Medical, absolutely innocuous, right? Everyone wants to fight COVID-19. Now, my issue, though, is this infrared company in China doesn't produce only thermometers. On the website or through further digging, I can see that they also support defense customers in China. That's just 10% of their business. Now, even though I have a fabulous end use, right, my measuring device will be used to test COVID-19 thermometers in China, and I'm going to send my engineer, know they're going to be used for that. Okay, that's not the issue. The issue is they fall under the definition of a military end user because they overall support military end users in China. So again, it's a bit tricky. Same with military end use. So I've got an aircraft part, all right, and I'm in the U.S. or I'm abroad, and my product falls under the EAR. And I have for this aircraft part end users, and I know this from military aircraft, civilian aircraft. Now, for this one project, I'm going to actually ship this to China Airlines, okay, civilian. I'm going to send my engineer. I know it's going to be used with China Airlines. It's going to be incorporated. It's not a problem. But I know that I have customers who use this for defense purposes. So that partner falls under the definition of a military end use, even though for this particular transaction, it's completely fine, not be innocuous, right? So again, it's a broad catch-all that when you think about them on its face, if you ask someone on the street, right, private sector company for the thermometers, is that a military end user? They would say no, right? Is this a military end user? If I send a part and component to China Airways and I will install it, I know it's not going to be diverted. Let's just say, again, that could be a surprise here. So it's important to do what? To understand whether an item falls under the EAR. That's important for folks listening in from outside the U.S., right? It's the eternal issue, does my item fall under the EAR? And we're all much more zoomed in on that, right? We're not just saying, oh, it doesn't really matter, right? Same controls as if my item was controlled in the EU. Now it really matters because I could get out of these regulations. I could get out of the EAR if it's not subject to the EAR. So de minimis matters, the direct product rule matters, and the like. And then, of course, the classification matters, right? Because this, for example, does not apply to ER99 items. So going back, that's why, working with classification specialists, and I'm so happy that I can work with David, is so important because it's oftentimes gray, right, what classification is, and it's important to understand the technical thresholds and implications. So that was 744.21. I spent some time on that because it is one of the key changes, and it's not going to get better. And I mentioned again for Russia and for Venezuela, but that is, again, a key development under the EAR that has kept many of us really scratching our heads. The next change was BIS eliminated license exception CIV, which was a very nice license exception. We really liked that one for China. It was simple. You had to basically say as a civilian end use, not that much due diligence. There was not really that much of an inquiry from BIS either, but it was almost too easy, right, for China. So that's gone. It's gone overall, not just for China, but for China it was particularly useful. The direct product rule, again, I mentioned it earlier, is a rule that has been on the books for a very long time, but it has been expanded. So that was the one that I mentioned earlier. I'm producing a laser, say, in Japan or in France. There's no U.S. content at all. I don't have a de minimis issue, but my secret sauce comes from the U.S. or my software. I'm using software as a tool, design software, and that could have implications that could turn my French product, my Japanese product, into an item that is subject to the EAR. And that was now expanded for Huawei and its non-U.S. affiliates, essentially at this point almost all of its affiliates, through a footnote 1 designation, the entity list. It's a little tricky. Many of you have seen it. You go to the entity list, and if there is a footnote 1 in the restrictions description, you see that with Huawei, it means that the enhanced or stricter direct product rule applies. And it goes beyond what I said earlier, where we look at, the laser that we're producing abroad and the secret sauce falls under NS, and I produce something that falls under NS, and the destination is country group D1 like China. It now catches much more. It catches technology or software that you're using. Think of software as a tool, not software that goes into your product, but software as a tool that falls under ECCNs that are listed there. And some of the ECCNs are, for example, 3D991 that are AT controls, so much lower controls than we've had under the traditional direct product rule. It also has another provision that if you are outside the US, say in Germany in the semiconductor space, and you don't incorporate anything into your product, right, into your chip, let's say, for Huawei, and you don't get any technology from the US. This is all German technology, German know-how. But in your facility, you have equipment sitting that came from the US, or it's caught under this. Could be a measuring device, testing device. Then your chip, even though it doesn't contain any US content, physically, parts, components, materials, and it also, of course, doesn't include any software. Chip would include that, but doesn't include any software because you used this equipment to develop, produce, or, for example, test it. This product is now subject to these restrictions for Huawei and its affiliates. So that's a problem. At this point, the only entity that is caught under footnote 1 is Huawei. That's nice. We were worried SMIC and others could get caught as well. SMIC was added to the entity list, but not under footnote 1. But it'd be very easy, right, for BIS to add anyone else under footnote 1. This really is adding a footnote to the entity list designation. That's all it takes, and this rule applies. So where this is important for folks in the semiconductor, telecommunications, and computer industries in particular, and anyone who produces equipment for those industries. Next slide. Then in October, BIS also changed its national security licensure policy, and what it means is that if you have submitted a license application to BIS, for example, for an FBA that falls under 6A003, or any other item that falls under an NS control, BIS will also look into whether this item could make a material contribution to the development, production, maintenance, repair, operation of weapon systems in China. Again, this is all linked into the concern of, the defense industrial base in China, and not in any way aiding that effort. In December, BIS also issued the military end user list. Okay, so as I mentioned earlier, one of the key changes in 2020 was 74421, the expansion of that with military end users. Now, many of us have been, thinking about, okay, so how do I know whether my customer is an end user that falls under the military end user definition, and have come up with compliance procedures and techniques and trained folks, and have repeatedly told BS, you know what, it'd be really helpful if you would come up with a list as well, because there's asymmetric information. You know much more than the private sector will ever will about concerns that you have on the ground. So BS came out with a list, which is nice, right? So if someone is on the list, you don't have to do that much due diligence. You basically know this is an MEU, but also just eyes wide open. If you are searching someone, you're doing due diligence for a company, and they're not on the MEU list, that does not mean that they don't fall under the definition. Otherwise, it would be too easy, right? And of course, just like with Hong Kong, many entities have been added to the entity list, and also individuals have been added to the SDN list. Next slide. All right, Russia. We go through this a little bit quicker because many of the same changes apply here that we have with China. So first of all, Russia was, if you like, degraded. It was no longer in country groups A2 and A4. So country group A is good, right? D is bad. So degraded here because of concerns also of, items being diverted for prohibited end users or end users in China. Then Russia was added to country groups D2 and D4. That all has implications for licenses, policies, and license exceptions. Then the second point, that's exactly the same as I said earlier for China, the 74421, right, where I may have an item that falls under an AT control. Normally that'd be great for Russia, right? I only have to think about prohibited persons, destinations, end users, and maybe a link to Crimea. So now it's way broader. No one is listed, but I would still have to do due diligence if my item falls under supplement number 2 to part 744, because it may fall, that customer may fall under the military end user definition that, as I explained, is very broad, or military end use restrictions. Same change to the licensing policies I mentioned earlier, because of concerns, potentially aiding weapon systems in Russia. Then the MEU list, I mentioned that in December. This is the new list that you find on the BIS website right under 744, like after the entity list, that shows you who BIS views as military end users. But again, that it's not comprehensive. You still need to do due diligence. If someone is not on the list, you're not off the hook. And of course, also various entities and individuals being added to U.S. sanctions list, the SDN list, and then also the entity list for entities. Next slide. Venezuela, so again, 74421 applies to China, Hong Kong, Russia, and Venezuela, so the same change here, same change for the policy. Now, with the MEU list, I checked as of this morning, there's no Venezuelan entity that has been added to the MEU list, and the last iteration was of 114, and also, entities and individuals have been added to various U.S. sanctions, so it's been a pretty active year for Venezuela too throughout 2020. Next slide. Okay, now country-specific changes. So Ukraine, no longer, again, if you remember, some of you know this, but for those who don't, so country group D is bad. Ukraine has been removed from country group D. That's good. And is now country group B. That's significant. So for any of you who are interested in transactions with Ukraine, so that means, for example, if you're in country group B, there's a very nice broad license exception, which is probably the easiest one available, GBS. So that is now available for Ukraine. It doesn't apply to all ECCNs, so you'd have to check whether that ECCN is eligible for GBS. You see that right in the ECCN entry, but it's a really easy, if you like, license exception to use when it applies, and also license exception TSR for technology and software. We used to have an issue with Ukraine because there are actually some companies that use contractors in Ukraine for software development. That was a problem because of what I said earlier, even for mass market encryption, where the actual software hardware falls under lower control, a 992 control, the technology to develop or produce those items was under high control. There's a difference there. Under 5E002, so one needs to use 74017B24B, and that is not eligible for country group D. 1, for example, and Ukraine is no longer there. So now that's no longer an issue, which is good. Mexico and Cyprus also on the positive side. It's not all bad. On the positive side, Mexico and Cyprus are now in country group A6. That's good for those of you who have, for example, national security controlled items, highly controlled items that are where one could use license exception STA, Strategic Trade Authorization. You will see that, but looking into the ECCN, it will tell you whether STA applies, and it will also tell you when you go through the analysis whether A6 works. Sometimes only A5 works, but that's again a good change here. Yemen has been kicked out of country group B. That's not really surprising, right? If you're following the developments in Yemen, like way too unstable. Sudan here also on the positive side. Sudan, we already had a couple of years ago changes on the OFAC side. OFAC already indicated that Sudan was no longer subject to the embargo, essentially. But we had on the AAR side restrictions, and why? Because the State Department viewed Sudan as a state sponsor of terrorism. That has immediate implications, as some of you know, under the EAR. That means that you are now in country group E, which is, of course, even worse than D. That's the worst list to be on. Sudan is no longer in country group E. We have in country group E, Cuba, North Korea, Iran, and Syria. Crimea is not on it, fully embargoed, but not on it because Crimea is not a country, and it is part of Russia or Ukraine, depending on how you do that politically. But again, Sudan is no longer in country group E. That is a very big change. What does that mean? That means that if I produce items outside the U.S., my de minimis threshold is no longer 10%, but 25%. That's good. AT controls no longer apply for exports to Sudan. Then, though, there was some confusion here. BS has now clarified that even though Sudan is now in country group B, license exception GBS, the one that I mentioned earlier that is so easy, and TSR are not yet available, maybe because it would be too easy to apply. What does that mean for Sudan overall? Just in a nutshell, it means that one can now export items to Sudan unless they're listed on the Commerce Control List with a restriction for Sudan. But it'll be the same if you export, say, to the UK or Germany, right? The restrictions depending on the entry. If there's no restriction, for example, because they fall under ER99 or only, quote-unquote, under an AT control, one could export to Sudan, but you'd have to do additional due diligence, right? It's way too new for everybody. I mean, there's no real reliable corporate record search that you could do, so you should certainly get an ownership questionnaire, understand who stands behind the company, who owns it directly, indirectly, try to do at least that due diligence, right? Know who the directors and officers are. It is still, and what we would say, an SDN-rich country. A number of individuals and entities are listed on the SDN list in particular. But interestingly, the 744-21 restrictions don't apply to Sudan. This all could change, right? Volatile country, if they don't continue, I'm simplifying it, so basically doing what the U.S. expects it to do, the sanctions could snap back. We've seen this with Burma, you just saw a few days ago. There were sanctions against Burmese individuals. There could be more to come here with Burma. We expect that. So again, the same with Sudan. It's always a risk when you go into a country that was embargoed and where sanctions have been lifted. Next slide. License exception CIV is gone. I mentioned that already. Then for folks outside the U.S., there's license exception APR, additional permissive re-exports. It's kind of a nice license exception, but BIS wants to change it. It's almost too easy when it applies. And why does it want to change it? Because it really doesn't trust its trading partners, put simply. So this works from BIS's perspective. If I can rely on the EU, for example, not allowing shipments to places where I don't want those items to go, but there's a bit of a discrepancy now, if you like, especially on China, at least from the U.S. perspective. So BIS wants to implement changes there regarding license exception APR. Next slide. Next slide. We move on to OFAC. OFAC, 3 key changes. We now have a Chinese military. Again, you see the same paradigm, right? Companies sanctions list. There was an executive order that came out. Now, put simply, this list is very different from the BIS list conceptually, in the sense that the OFAC sanctions that apply here to companies that fall under this executive order that OFAC has designated, this is an issue if you trade in securities of those companies, right? Large Chinese companies. If you export, re-export, transfer items to them, these sanctions don't apply. So again, this is an issue for companies that trade in these securities or intermediaries like brokers. On the Iran sanction side, we have a real broadening now of the sanctions. This may change under the new administration, but 2 key developments. One is Executive Order 3902 from the beginning of 2020, which targets construction, mining, manufacturing, and textiles. So construction and textiles weren't really targeted before. We work with some companies, non-U.S. companies that were in those fields. Now this is a problem. You know, we have secondary sanctions, if you like. If you are a German company in the textile industry, you can be placed on the SDN list, put simply, if you're involved in significant transactions involving the textile sector in Iran. And then you see this, I highlighted this, or any other sector, right? That's a problem, and, you know, gives flexibility. OFAC used that, and in October, any other sector is now the financial sector, was now identified under Executive Order 3902. So that means there were additional sanctions imposed on the Iranian financial sector. Now, for those who've been following that, stuff already, I mean, really, as a matter of fact, already, you know, before that, every Iranian bank was designated on the SDN list just because it was an Iranian bank. But now it's worse, if you like. For those who export medical devices, medicine, and food to Iran, there are still some banks that can be used, but it's getting really more complicated. If you have questions about that, let me know. And then we move on to the end. Let's go on to OFAC enforcement cases. Next slide. So there's been a number of enforcement cases, right? We're not able here, we may give another webinar on that just because it's kind of fun and interesting to go through all the OFAC enforcement cases, but we don't have enough time for this presentation. So I picked out 3, just because I thought they were interesting. So one we have here was Keysight. What do we see here? So Keysight, U.S. company, okay? This is interesting because it shows a theme with OFAC, and it has to do with M&A, right? Mergers and acquisitions. I buy a foreign subsidiary, and I do due diligence, and I find out that, oh, sure enough, they've exported to Iran. Now, maybe that was not an issue because maybe that was during the Obama time, so we had an Iran sanctions relaxation, but it's a red flag, right? So here, Keysight did the right thing. It actually did quite a lot of things. If you read the case, it told this Finnish subsidiary that it was going to buy a night. You can't do that. Told them that pre-acquisition. You know, you can't export to Iran once you belong to us. And then a month afterwards, it told Anad you can't do that, and implemented sanctions procedures and restrictions and whatnot. But as it happens, right, behind the scenes, the vice president for Europe, Middle East, and Africa, and the regional director talked about that and said, this is really bad, right? I mean, we're going to lose our credibility in the market, in the region, if we don't export to Iran. So they came up with different ways to export to Iran by omitting or replacing references to Iran and putting in the UAE and whatnot. Keysight found out about it and voluntarily disclosed those violations and worked with OFAC and implemented additional compliance. And there was a penalty, though, which is actually, I would say, pretty large, considering what it had done pre-acquisition, post-acquisition, that it voluntarily disclosed the violations. Now, I know the cynics among you will say, why would you ever disclose? But there you have it. This is, from my perspective, the takeaway is, again, M&A deals, that there is a risk, and it's just so hard, right, to control what happens behind the scenes here. Next slide. BitGo. So BitGo is interesting to U.S. companies. It's interesting because David and I, we work with companies that are in the e-commerce field, just like a number of you. And when we talk about, you know, when someone signs up and you really need to screen them and folks go, what do you mean? You know, they sign up online. We've got so many transactions. How can we take care of that? You know, it's complicated and there's just too much and we can't screen. And why does anyone screen online, right? Like they get it for physical items. But for e-commerce, surprisingly enough, there's still a lot of pushback about that. So this just drives home the case from OFAC with BitGo. So BitGo, the transactions amounted to $9,000. And the penalty was 10 times as much. Now, it's not a lot, not billions or millions of dollars, but, you know, significant penalty. BitGo is small. And what happened? They processed 183 digital currency transactions. And they did get the IP address, but they didn't put in an IP blocker, which I know can be circumvented, but OFAC likes the IP blocker. And they also only got the name and email address, not more. And sure enough, folks were in Crimea, Cuba, Iran, Sudan, and Syria, so that was bad. And they were penalized for that. And there was no voluntary disclosure, so OFAC had found out about that. Or maybe something came out and the OFAC didn't think it was enough of a voluntary disclosure. Next slide. Last case, given that we have a number of you who have died in from outside the U.S., this is a case with a company in Indonesia, has to do with North Korea. And we sometimes have to laugh, right? We had the nail polish case, now in the false eyelashes, now we have the cigarette paper going to North Korea. You sometimes think about, you know, don't we have more important things to do on the national security side than, you know, worry about cigarette paper going to North Korea? But here you have it. What do we have? We have an Indonesian company, right, not U.S. under control, that exported cigarette paper to an intermediary in China, perhaps also directly to North Korea, but it's always, oftentimes the intermediary, right? That's how things can go wrong. And that intermediary bought it on behalf of OFAC designated Korea Daesung General Trading Corporation. Daesung's been on the SDN for a long time. Was operating under an alias, but it looks like based on what OFAC at least said, that BMG, or at least some folks at BMG knew that, because instead of referencing Daesung, they used different references and tried to, you know, hide what was going on. And what was the issue? You're thinking, what's the U.S. nexus here? There's no U.S. product. The cigarette paper did not come from the U.S. Well, the U.S. nexus was a U.S. dollar bank account at a non-U.S. bank. You'd think when folks do business with embargo destination, they would not use U.S. dollars, but here you have it. It's not a U.S., you know, they're not a U.S. bank, but a U.S. dollar bank account. So if you use U.S. dollars, now the financial system is complicated, but you can just assume that at some point this will go through U.S. banks. And it did. It was cleared through U.S. banks. So 28 wires. And what happens then, as many of you know, under ITAR, there's a provision that says if you, foreign person, cause a U.S. person to violate the sanctions, you, foreign person, BMJ, cause a U.S. person, U.S. bank to violate the North Korea sanctions, then you can be equally penalized, and that's what happened here. Let's go to the next slide. So here we are at the end of the presentation. That was our last sanctions case. Again, there are several others, but I wanted to highlight these three. For those of you seeking CLO credit, today's CLO code is N as in Nixon, P as in Peabody, C as in cat, L as in London, E as in Echo, 21121. Again, N as in Nixon, P as in Peabody, C as in cat, L as in London, E as in Echo, 21121. And you will get this presentation. You'll have this information here as well for the CLO credit. This ends our presentation. I hope you found it helpful. The other items that we could have captured as well, but I know everyone's pressed for time, so I want to make this fairly short in 1 hour. And it ran you through, you know, what we think are the key ER and OFAC developments of 2020. Again, if you have any questions at all, feel free to reach out to us and we will answer every question you get. Thanks again.